Session.
Thank you. Please be seated. Good morning. We're here for oral argument and CV21 0477 Manoukian versus Manoukian. As you know, we do live stream and record these proceedings, so please give your name and the name of your party when you stand up to introduce yourself. According to protocol, you'll each have 20 minutes. You'll argue from the single podium. We do require that you keep track of your own time, including any time that you want to reserve. Keep in mind we have read the briefing. We've conferenced this case before we came out to the bench. And with that, counsel, you may proceed.
Good morning. May it please the court, my name is Mike McVeigh, and I'm appearing on behalf of the appellant in this case, Sean Manoukian. Mr. Manoukian is here with us today. I'll be referring to him as husband. Also at the table is my partner, Bob Hauser. And with the court's permission, what I'd like to do is reserve about 3 minutes for rebuttal time. As your honors know, this Arizona case is now more than 2 years old. This appeal is not the first time this case has been before the court. The Superior Court dismissed this case once before for forum nonconvenience, a dismissal this court vacated in a special action. Yet, on remand, the Superior Court dismissed the case again on the exact same ground and briefings. Following remand, the trial court committed 3 errors, each of which should be reversed. First, it abused its discretion when it set aside wife's default without finding either excusable neglect, there was none, or a meritorious defense. Second, it committed legal error and abused its discretion in dismissing the case for forum nonconvenience. And third, it awarded wife attorney's fees in the amount of $113,000 pursuant to 25-324 without a hearing and without a basis for disparity in financial resources between the parties. It improperly concluded but failed to explain why husband took unreasonable positions during the course of the case. This court should reverse the second dismissal and remand the case so husband can obtain the divorce he first applied for back in March of 2020. Your honors, we have limited time. Subject to whatever questions the court may have, I want to focus on the forum nonconvenience dismissal. Time permitting, I will address the court's erroneous refusal to enter the default and its erroneous award of attorney's fees. If we cannot get to these issues, we respectfully rest on our briefs. Just some brief factual background, because I know the court has read this and you've also conferenced it. But these parties were married in 1995. Prior to their marriage, they entered into a prenuptial agreement pursuant to the Arizona Uniform Premarital Agreement Act. Each party was represented by independent counsel. That agreement separated the parties' assets. It provided wife monthly funds, which she has received over the past 25 years of the marriage, and the agreement precluded an award of spousal maintenance upon divorce. Finally, and most importantly, that agreement also provided that the agreement was to be governed by Arizona law. The record is uncontested that for 25 years, wife accepted the benefits of that agreement, and her counsel told the trial court as late as July of 2020 that husband was providing wife $17,000 a month. Neither party, nor the trial court claimed the parties' negotiation or execution of the agreement had anything to do with the state of Tennessee. Mr. Manoukian is now 86 years old. He's been a resident of this state for more than 40 years. He has multiple businesses and owns at least 5 parcels of real estate. Virtually all of his personal and business records are in Arizona.
Are they an issue in the, given the prenup?
I'm sorry, Your Honor.
I don't know what's wrong with the sound today, but we all sound a little muffled. Given the prenup, are those properties and business interests that you just identified really at issue in this case?
They are in the sense that wife has contested the prenuptial agreement, and these businesses are all the sole and separate property under the terms of the prenuptial agreement, are all the sole and separate property of Mr. Manoukian.
Okay, so that doesn't seem to argue very well toward the importance of Arizona as a forum. If he's going to have these pieces of property as a sole and separate property no matter what, why would Arizona have an enhanced interest in handling a bifurcated divorce?
It would have every interest in enforcing an agreement reached between Arizona parties who reached an agreement, just as in CalFed, Arizona parties who reached an agreement calling for the governance of Arizona law. If the prenuptial agreement was not followed, as we believe it should be, and we believe as the trial court should have done on the motion for partial summary judgment, then there are arguments that wife has an interest in those business, whether it's because they were acquired during the course of the marriage, or whether under principles of Cockrell and other cases, community efforts were used to enhance the value of those separate businesses. That's why this prenuptial agreement is so important to this case.
Do you have any reason to believe it wouldn't be enforced according to its terms and Arizona law by a Tennessee court?
Well, we can tell you this. If you look at pages 25 and 26 of the answering brief, the wife and her counsel make the argument that Tennessee will not enforce the agreement according to Tennessee law. We don't take that position, but on pages 25 and 26 of their answering brief, they argue to this court that Tennessee will not enforce the agreement because it's in violation of Tennessee public policy.
But your reply brief tells
Excuse
us
me?
that that's not the case in your view.
I'm sorry, Your Honor. I'm catching some feedback.
Your reply brief, though, addressed that you don't think that's the case. I mean, you cited case law about that Tennessee would go ahead.
We don't think that's the case, but it gets to why we are here. This is not a forum nonconvenience motion. This is a forum shopping motion masquerading as a forum nonconvenience motion because they do not want to litigate this case in Arizona. They would rather take their chances in Tennessee because Tennessee shifts the burden of proof in prenuptial agreements.
But is that a factor we consider, what the intent of the party is in seeking a motion like this? I mean, clearly the Tennessee has home state. Everyone agrees that the child issues have to be dealt with in Tennessee. So they are either proceeding in two forums or they can proceed in one. I mean, the idea about their intent, I'm not sure how that plays into how the court, our view of whether the court abused its discretion in coming to evaluate these factors and weigh them in a way that you disagree with.
Well, first and foremost, I think that, as this court knows, this court has long held that there is a doctrine called duplicative proceedings. Or the
I'm sorry, could you say that again?
I'm sorry.
We're all having trouble hearing one another today. Could you say that one more time?
Yes. This court has long recognized the concept of divisible divorce, where different aspects of a divorce case are tried in different fora.
It can surely exist, but before we intuit too much about your colleagues' motives in wanting to go to Tennessee, we know for a fact under the UCCJEA that Tennessee has to be involved.
Correct.
So we can do this in one court or two courts.
Correct. But they are separate issues. Arizona has a very simple role to perform. That is to address the prenuptial agreement, determine whether it's valid, if valid, distribute the assets and the liabilities of the parties in accordance therewith. If the court determines that it's not valid, Arizona still has the sole responsibility of addressing the division of property and the division of debt, perhaps addressing spousal maintenance. But Tennessee has an entirely different role to play. Its role is to determine child custody and child support. And as far as any potential duplication of evidence or the risk of inconsistent results, we don't think that's present. And the reason we don't think it's present is because any ruling by an Arizona court on the limited issues that are before it will be given issue preclusion effect by the state of Tennessee.
No.
Can you talk to us about our standard and finding the court abused their discretion in making this determination when the special action instructed the court to not only address the factors but weigh them and come to a determination, which the Superior Court clearly did? You disagree with the weight that was given to different factors. How are we to use that to find that the court abused its discretion in coming to a decision that you don't agree with?
Okay. First, your Honor is correct. The standard is, did the trial court abuse its discretion? Let's begin with the premise that the plaintiff is entitled to his choice of forum, and a court abuses its discretion by misapplying the forum nonconvenience factors. In reviewing a motion to dismiss, this court has to view the facts in a light most favorable to the non-moving party. What are the core legal standards that the court has to apply? Well, the court has addressed those in both PARA and in CalFed. I think those are the two most important cases. Both come from this court, although CalFed came from Division II. First, it's the plaintiff's right to choose his forum. Second, the law...
Do we need to look at PARA any differently in the sense that in PARA, our court did the weighing of the factors, because while they found that the Superior Court in that case determined what the factors were, they hadn't weighted them. And so we went ahead and weighted them because there was a factual record that allowed that, where in the special action, in your case, the court found there wasn't enough factual basis to make any kind of weighing of what those factors were. So do we look at PARA any differently based on that procedural aspect?
Well, if I understand the court's question, I think what you're asking is whether the Superior Court abused its discretion and whether it misweighed the factors.
That was my original question, right?
And the answer to that question is clearly yes, and there's 4 reasons for it. In its second go-around of the forum nonconvenience analysis, the trial court committed, in our view, 4 errors. Number 1, in paragraph 22 of its minute entry, it implied strongly more than one proceeding was itself an unacceptably inconvenient factor. It incorrectly concluded that duplication in the proceedings between Tennessee and Arizona, we don't believe there will be any, thus concluding the forum nonconvenience factors were not closely balanced and that these factors tip strongly in favor of Tennessee. Second, and this is a very important one from a public policy point of view, we believe the trial court also fatally misperceived Arizona's significant interest in the enforcement of a prenuptial agreement like this, one signed by 2 Arizona residents, entered into in Arizona, concerning a marriage of more than 2 decades in Arizona, and governed by Arizona law. Instead, the court gave equal weight to Tennessee's interest, which, as wife concedes, has a strong public interest against enforcing prenuptial agreements like those of that Arizona endorses. We believe the trial court committed legal error when it presumed evidence existed in Tennessee.
Well, when you say presumed, you talk about the fact that she uses the word may when she talks about evidence that may be in Tennessee. But I noticed in the minute entry that she uses may throughout her factual findings, including to findings that were stipulated to by the parties as far as who witnesses would be. So
she did. She did, and I will acknowledge that to you. But when it comes to presuming evidence, as Bills versus Nixon pointed out, a trial court is not free to assume that there's evidence. There has to actually be evidence in the record before the trial court takes from a resident plaintiff his right to file his case in Arizona.
Well, is it much of an assumption that there would need to be people who would evaluate the property in Tennessee? I mean, there obviously is a difference of opinion about whether wife's property is a business, is not a business, is community property, is not community property. So is it that big of a leap that she's abused her discretion in saying that there may be witnesses in Tennessee as to that disputed piece of property?
Well, again, if the best the trial court can do is say there may be witnesses in Tennessee, that's insufficient. There has to be in the record actual proof that Tennessee has a significant number of witnesses, a significant amount of evidence. What you have is a single parcel of property that wife calls a farm. There is no evidence in the record, and I defy counsel to point it out, that there is an operating business from that property. There are a handful of chickens, goats, and other small animals. There are no crops grown there other than a small vegetable garden. And there is no evidence in the record that any animals are slaughtered or sold from that property. It is a fable. And the record doesn't support that claim. Finally,
if the prenup is enforced, is any of this evidence actually relevant? If it's enforced according to its terms and according to Arizona law, We don't really care how many goats are on this property, do we? The agreement just
No,
gives
we
us the
don't.
result.
We don't. But if the agreement is enforced, there's absolutely, as we believe it should be, there's absolutely no duplication in the evidence for all the reasons I've stated previously. The role of Arizona, which is to dissolve the marriage and distribute the assets. The role of Tennessee, which is to determine the best interest of the child and to award child support in an appropriate amount. So I agree with Your Honor. And we believe that augurs in favor of keeping the divorce case in Arizona.
Well, I guess it depends on how much faith you have in the Tennessee courts, because if you have faith that they're going to apply the agreement as written, it really shouldn't matter who hears the case, right? Because there's no witnesses, there's nothing to determine factually. The agreement has already covered it.
It absolutely should matter for all the reasons this court said in CalFed. In CalFed, which was issued by Division II of this court said there is a great advantage in having this state resolve issues that are governed by Arizona law and not some foreign jurisdiction which is left with the issue of untangling it.
But in fairness, Caltech didn't have those, the issues there could easily have gone into one jurisdiction. Where here we're going, if Arizona hears the dissolution matter, there are going to be two places where evidence has to be taken in this case, and that wasn't the case in Caltech.
Your Honor, I respectfully disagree. If you read CalFed, what you find is that arising out of the same contract to purchase an apartment complex in Phoenix, Arizona, there was a breach of contract claim in Arizona, and there was a competing fraud claim in the state of California.
Right.
The plaintiffs in that case, unlike Mr. Manoukian, were not Arizonans. They were Californians who brought a case in Arizona because the case was governed by Arizona law. And the court found that despite the fact that they were non-residents, the fact that the contract called for governance of Arizona law was dispositive. Additionally, the court also pointed out that even though there may be some duplication in the various claims of the contract case in one state and the fraud case in another state, that was not sufficient to set aside the plaintiff's motion, the plaintiff's complaint in Arizona. So we think CalFed is probably the most important case this court can analyze in reaching its decision.
Counsel, I know you said you wanted to reserve 3 minutes, but I have a question on the default.
Yes, sir.
So husband's petition was filed March 3rd of 2020. 6 days later, wife asked to go to conciliation court, and the matter is stayed.
Until May the 20th.
Until May the 20th. The week before that, on May 14th, wife filed a motion to dismiss unformed nonconvenience. As I read, and that was the primary motion that was before the court, then it was special action, then the court addresses it again. Under Rule 24.1, where we talk about timing on filing a responsive pleading to a petition, in 24.1, you have 10 days to file your response after the motion to dismiss is ruled upon.
Correct.
And
That's
so
assuming it's an appropriate Rule 29 motion.
Okay.
And this motion was not a motion recognized by Rule 29. It was a motion outside the 6 exceptions in Rule 29. Rule 29 is the equivalent of a Rule 12b-6.
So let me ask you this then. So once the petition is no longer stayed, as of May 20th, 2020, is it your position that wife, her time was running, the 30-day time?
Yes, sir.
Picked back up and she had to file?
It is. And our calculation is that I believe I'm correct on this. June the 23rd was her 30th day after being served in Tennessee. Because she's out of state, she had 30 days, not 20. And we filed our application for default on July the 6th, about 3 weeks later. And I just want to let the court know this. They claim that they were shocked and surprised to find out that there was a default. They had no reason to be shocked and surprised. If you look at the application for default, it's in the record. We put them on notice of the legal issue. We gave them a short memo and said, you haven't filed a response, Rule 29 doesn't apply, and here's why. You don't normally see that in an application. In addition to that, on August the 24th, when we filed our motion for partial summary judgment, we put them on notice a second time on page 2 of the motion for partial summary judgment that they were in default and that Rule 29 did not apply. So they had a full 3 months before we filed our request for a hearing on the default.
Thank you. I know that cut into your rebuttal time. Thank you.
Well, I'm pretty much out of it anyway.
Okay.
I thank the court. I'll just summarize by saying this. We believe the court acted improvidently. We believe that this court should reverse the, well, first and foremost, it should enter a default because of their failure to file a timely response and the lack of any excusable neglect or meritorious defense. If the court chooses not to do this, we believe that it should reverse this case on forum nonconvenience grounds, send it back to the trial court with directions to vacate the attorney's fees, address the motion for summary judgment, and then proceed on with the Arizona divorce case only. I thank the court for its time.
Thank you.
When you're ready.
Excuse me, Your Honor. Thank you, Your Honor. May it please the court. Roger Cohen on behalf of respondent Catherine Manoukian. My partner, Kathy Sandweiss, is with me. There's something to be said at the beginning. Why are we here? We're not here because of forum shopping. We're here because of husband's scorched earth approach to litigation. Because he's decided that he will give no quarter. He will make no allowances. He will insist on compliance with every technicality. He will do whatever he can to prevent the wife from even having access to legal services up to and including posting a supersedious bond to make sure that we don't get paid. This is extraordinary litigation. And the entire case needs to be considered with that backdrop. Why are we here 2 years? Why is it taking so long? So here's what happened.
This isn't the first family court case in which parties don't like each other and fight pretty hard. I'm not sure that really bears on the merits of what we're here to do today.
Here's why it does, Judge Swan. It does because the issues that are being appealed here are all matters of discretion. And what the husband is asking this court to do is to step in and override the trial judge's discretion, which is an extraordinary thing to ask, including, again, as to attorney fees. And there is an extraordinary imbalance. I mean, the evidence in the record here shows that Mr. Manoukian has $700,000 to $800,000 a year in income, and the wife has zero, other than what, the handouts that she gets from him. In the Tennessee case, it's disclosed that he's spent over $500,000, $500,000 litigating this case. And yet he's asking this court to prevent the wife from even having the ability to defend herself. Consider the extreme position that's taken on attorney fees. They're saying, well, you have to wait to the end of the case. And that's pretty extraordinary because the litigation is going on. And if you follow their logic to its extreme, no party with the lesser resources would ever be able to litigate, ever. Because they can't, the spouse, whichever spouse, if unable to afford to hire an attorney, and by the way, we're proceeding because we feel an ethical obligation to do so, because we took on this case and we're not going to bail out. But if she went to another lawyer said, well, how are you going to pay me? Can't take it as a contingency because that would violate the ERs. That's what we're dealing with. But let's talk about...
Counsel, let me ask you a question on the forum nonconvenience. If the Superior Court had denied your client's motion to dismiss the case to Tennessee, would that have been an abuse of discretion? If your motion to dismiss had not been granted, would that have been an abuse of discretion?
That's hypothetical, Your Honor, but I can't say that it would or wouldn't, because that's the issue. The issue is discretion. The issue is not who's right and who's wrong. And what we heard a lot of in appellant's argument is, well, court made a mistake here, the court made a mistake there, the court didn't do this, the court didn't do that. And I think one of the things that we need to look at is the
If I understand your answer to Judge Williams' question, though, it's that this could have gone either way.
I'm sorry, Your Honor?
This could have gone either way.
I think that's right, Your Honor.
Okay.
But here's the thing. There's a significant difference in the procedural posture of this case vis-a-vis PARA, and that has to be looked at and taken into consideration. In PARA, the procedural posture was essentially the same as this case when it went up on special action. I'm reading from the PARA decision. Although the Superior Court cited the relevant factors, it did not make findings, paren. The parties did not ask it to, close paren, explaining how it weighed the evidence relevant to the applicable factors. We therefore review the record to determine whether substantial evidence supports the court's exercise of its discretion. That's a different approach, because in that case, the PARA court was called upon to consider the various factors and to express its opinion on whether the factors do or do not apply. In our case, we have something completely different, because if the court recalls, what happened is it went up on special action, and this court on the special action decision said, well, we don't know. We can't tell from this record whether the court weighed the proper factors, and so we're going to send it back to the trial court to do it again, to, in essence, show the court's work. So the case goes back to the trial court, and exactly what this court asked the trial court to do. There was another hearing, there was another ruling, but this time the ruling goes through the factors exhaustively. And we know what the court did. We know what the trial judge relied on. And we know that unless the court is willing to say, well, no, there was no evidence to support that, none, those findings are binding, and those are to be given deference to this court. In this court. So it is a significant matter to keep in mind that in this appeal, everything that the appellants are asking the court to do is to override the court's exercise of jurisdiction. That's a high burden.
I'm trying to understand why 2 appellate proceedings have been required just to figure out where this divorce is going to take place. What does your client care if Arizona or Tennessee applies a prenup? Why are you fighting about this so hard? Is it that, as your colleagues point out, you expect the Tennessee court to simply ignore the Arizona law? What's the advantage here? This is a lot of money for what?
Your Honor, actually, it's not that complicated. In fact, it's very simple. In Mrs. Manoukian's deposition, she was asked that question repeatedly, and what she said is she doesn't want to be litigating in 2 states at once. She doesn't want to have. She lives in Tennessee.
I mean, we're here now, second appellate proceeding, and we haven't even gotten to the very first contention on the merits. So for someone who doesn't want to be litigating in 2 states at once, we're certainly spending a lot of time doing it. And I get the sense that we, on this court, may be missing the context here. So I'm asking for you to clarify.
Our client has not appealed. Our client has not appealed any orders of the trial court. Why, Your Honor, would it be
your client
put
is
on?
not the appellant, but you are fighting to be out of Arizona.
And the court has repeatedly ruled in her favor. I mean, yes, it's taken 2 years, but at least half of that time has been just waiting for the process to play out. Why is it
Why not just agree to do the property stuff in Arizona?
because of the expense? Because if she's going to litigate some issues in Tennessee, and we know, Judge Swan, we know there are issues that have to be litigated in Tennessee.
Unquestionable.
If she's going to have to litigate in both states, she's got to have two sets of lawyers, which she now has, but she wouldn't have if it goes to Tennessee. She's got two sets of clocks running. She's got a significant amount of additional expense, but more than that, Your Honor, the issues overlap. And although the appellant in his brief denies that, it's simply not true. And here's how we know, and it's not hypothetical. All we need to do is to look at the discovery promulgated by the husband in this case to see how the two proceedings are enmeshed and overlapping. Refer the court to Index of Record number 91, which is wife's response to the motion to compel. Exhibit B are non-uniform interrogatories propounded on March 11, 2020. And I'm just going to refer to three particular interrogatories. I don't want to burden the court's time, but number 2 asks, prior to or during your present marriage, were you ever engaged in gainful employment, whether full or part-time? And then there's a whole series of questions about hours and salary and education. Now, those are things that, obviously, to deal with one of the points, the question that was raised earlier, if the prenuptial agreement controls, those questions are irrelevant, but this is the husband's way of litigating. So we've got those questions being asked in Arizona, and yet they go directly to issues that are being litigated in Tennessee, including child support.
Right, they are relevant.
And then number 4, do you believe you are entitled to an award of spousal maintenance in this divorce proceeding? And then a series of questions about that. And then number 5, with respect to each item of property of any type or nature you believe will be awarded at the conclusion of this divorce, state the fair market value of the property, state any income you will derive from the property, state all expenses related to continued ownership of the property. Those are things that are overlapping, duplicative of issues that are being litigated in Tennessee, whatever happens here. And so what is motivating our client is not some forum shopping, not some idea that I'm going to get a better shake in Tennessee. It's I want this combined so that I can stop the craziness, stop the duplicate expense, and have one fair trial, one fair hearing in one litigation to resolve all of these duplicative issues. It's no more complicated than that, Your Honor.
All right, thank you.
All right. Now,
Do you want to talk a little bit about your view on the default?
certainly, Your Honor. I mean, the default. First, the chronology that was given was not correct. The
Counsel, husband's petition was filed March 3rd of 2020, correct?
I believe that's correct.
And then it was March 9th of 2020 that your client asked that the matter go to conciliation court, correct?
That's correct, Your Honor.
And at that point, the petition was stayed, correct?
It was stayed for some period of time, and
Until
then
May
there
20th.
was. I'm sorry, Your Honor.
Until May 20th of 2020, correct?
I'm not. I can't hear you.
Okay.
I apologize.
Go ahead. Go ahead and address the timing of the response that was due. When do you think wife's response was due?
Well, wife's response was due on or before the date of the motion to dismiss for forum nonconvenience. And so there was 30 days. It was during that 30-day period that the wife was called upon to respond. Wife filed a motion under Rule 29, which, the argument is, that a motion for forum nonconvenience and a motion for the dismiss for improper venue are two different things. But that is a hyper-technical look at the rule. And what the wife believed, and it's clear, and no one said anything about it at the time, is that by moving to dismiss for forum nonconvenience, that satisfied the intent and the letter of the rule as to the
Well, they
timeliness
filed
of an
for
answer.
default. So, I mean, when you say no one said anything, they filed for default. So they were saying something.
Okay, they did, but not right away. Okay, on July 6, 2020, and this is 4 days before the court ruled on the motion to dismiss, the husband files a application and affidavit for default. And that starts a 10-day period for responding to the default. But what happened then is his petition is granted. The court grants the dismissal, and now we have this whole series of appellate proceedings to go with both a special action and an appeal. Goes up to the Court of Appeals. The Court of Appeals rules, and in the meantime, our firm had entered an appearance. And we come into this case knowing that the lawsuit is being actively litigated, back and forth, and particularly when it comes back down from the Court of Appeals. There are motions filed. There are discovery requests outstanding. One of the things that we were put on notice, well, you didn't respond to discovery that was propounded before the case went up on appeal. You're in default or violation of your discovery obligations. You got to respond to discovery. So we're litigating the case to death. Nobody says at that point, oh yeah, by the way, the 10-day period that had started to run before the case was dismissed.
Are you saying that you missed the fact that they'd filed for default because you came in late to the case? I'm not understanding
yes,
your
Your Honor.
argument
We had
about someone raising
of
something to you that
course,
they
Your Honor.
clearly raised by filing it.
Yeah, how would we have known to look for an affidavit of default in a record where what we knew was that the case was being actively litigated? So there was no reason to look for a default because everybody was treating the case as engaged and joined, and the parties were going about their business litigating as usual.
It's on the court's website, right? I mean, don't you look through the filings in the case when you take on a case?
Quite frankly, Your Honor, if I took on a case at the beginning and there was some question whether the issues were joined, I might look to see if there was a response. But in this case, we come into the case in midstream and the parties are actively litigated. And the short answer is no. It would never have dawned on us that maybe our client was in default and we better go look for that. Why would we look for it? And what rule is it that says that the 10 days begins to interrupted by the case being dismissed starts to run again? And what about the fact that the husband continues to litigate? And that the cases are clear that you can't have it both ways. If someone is in default, you got to treat them in default. If someone is actively involved in the case, then you litigate. And what the husband wants, they want to have it both ways here. They want to have the benefit of having litigated, filed their motions, filed their discovery, filed everything that they were doing on an ongoing basis to engage the issues, and at the same time say, yeah, but we didn't really mean that because you're in default. And you can't do that. That's gamesmanship, Your Honor. If they wanted us to file an answer, if they really thought we were in violation for not filing an answer, the professional thing to do would have been to write us a letter, an email. Hey, Roger, your client never filed an answer. We're going to take her default.
Counsel,
why didn't they do that? They didn't do that because it's all the technicalities. Yes,
Counsel,
Your Honor.
let me ask you this. I'm interested in your statement about whether the motion to dismiss for forum nonconvenience should be treated as a Rule 29 motion or not, because here's the timing as I understand it. Husband files a petition on March 3rd, 2020. On March 9th, 2020, 6 days later, the petition is stayed. The motion to dismiss, the first motion to dismiss for forum nonconvenience is filed May 14th, 6 days before the court lifts the stay. So if the motion to dismiss is the motion pending before the court, and it stays the pending motion before the court, special action, then it goes back, it stays the pending motion. So if the motion to dismiss for forum nonconvenience is a Rule 29 motion, in essence, wife's time to file a responsive pleading continued to be stayed the whole time.
That's correct, Your Honor. That's exactly right.
So my question is the motion to dismiss for forum nonconvenience a Rule 29 motion? And if it is, on what basis do we treat it as such?
Because the forum, I mean, it's Latin, but forum and venue, Your Honor, are one and the same. And there are cases in different contexts that treat forum nonconvenience and venue differently. But the policy is exactly the same. The policy is we're not going to require the parties to engage the merits of a case while we are litigating where the case is going to take place. And it's exactly that. The function of a ruled motion to dismiss for forum nonconvenience is precisely the same as the function of a motion to dismiss for lack of venue. And there's no logical reason to treat them differently.
Right.
But even if there was, the court had.
We're out of time.
I'm sorry?
I said finish that thought and we're out of time.
Okay, even if there was, the court had the discretion to treat the continued litigation as a waiver, which Judge LaBianca did, and the court had the discretion to treat the neglect and failing to answer as excusable, which it also did. And given the totality of these circumstances, it was not an abuse of discretion for the trial judge to treat the default as properly set aside.
All right. Thank you for your arguments.
Thank you, Your Honor.
We will take this matter under advisement, issue a decision in due course, and we'll stand in recess to reset for the next argument.